1968 ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ်680ဦးဆန်းလှ applicant first the Union of Burma respondent ဤစီရင်ထုံး audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစော်မင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Criminal Revision before ဦးစိန်သင်း Judge ဦးဆန်းလှ Applicant first the Union of Burma respondent Criminal Procedure Code application to quash the charge whether the session judge has power under section 438 Criminal Procedure Code to move the Chief Court to quash the charge. Hell, an accused person desiring to have the criminal proceeding started against him, quash must move directly to this court under section 561A of the Criminal Procedure Code. The session judge has no power under section 438 to move this court to quash the charge framed against the applicant. For the applicant, U Mya Shein for the respondent, U Sein Tin, Judge, the applicant U San Hla, along with one U Thon Yin, were prosecuted under section 19F of the Arms Act in respect of 10 rounds of ammunition alleged to have been found in the house of the latter. The allegations against the applicant U San Hla were that the ammunition belonged to him and that he had left them in the house of U Thon Yin, with whom he was staying together before the occurrence. It was also in evidence that a letter alleged to be in the handwriting of the applicant was also discovered along with the ammunition. The Lennon trial magistrate, after examining witnesses for the prosecution, discharged U Thon Yin under the provisions of section 253 of the Code of Criminal Procedure. As against the applicant, however, the trial court framed a charge under section 19F of the Arms Act. Being aggrieved with the said order, the applicant filed an application before the Court of Session, Pimana, praying that recommendation may be made to this court to quash the charge framed against him. The Lennon Session Judge, purporting to act under section 438 of the Code of Criminal Procedure, has recommended that the proceeding taken against the applicant may be quashed on the ground that the evidence did not disclose a prima facie case against the accused under section 19F of the Arms Act. It may be pointed out at the outset that an accused person desiring to have the criminal proceeding started against him, quash must move directly to this court under section 561A of the Criminal Procedure Code. The session judge has no power under section 438 to move this court to quash the charge framed against the applicant. On the merits of the case as well, the recommendation made by the Lennon Session Judge cannot be accepted. In an application to quash a charge, all that this court is concerned with is whether the court which has framed the charge had jurisdiction on the materials placed before it to act as it did. The principle to be followed in a matter such as this have been very lucidly explained in the case of U Nyi Le vs. The Union of Burma 1 in the following terms. It would not be proper for the High Court to interfere in the exercise of its inherent powers under Section 561A of the Criminal Procedure Code by questioning the proceeding at the stage of framing a charge, except 1. Where the prosecution allegations, even if accepted as true, do not establish any offense against the accused, or 2. Where there is no evidence at all against the accused to support the allegations which, if established, would constitute the offense. In the instant case before me, the allegations against the applicant clearly disclose a case which would be necessary for him to clear up. It cannot also be said that there is no evidence whatsoever to support these allegations. The question whether the allegations, if proved, would constitute an offense under Section 19F of the Arms Act or under Section 193 of the Penal Code is a matter which must be adjudicated upon after hearing all the evidence relevant to the matter in question. At this stage, it is not necessary to go into the question with a view to determine what offense the applicant had actually committed. As pointed out above, the question which must be considered at the moment is whether or not there is a prima facie case against the accused which would warrant framing of a charge against him. For all these reasons, the recommendation made by the learned session judge cannot be accepted. The proceeding will therefore be written with the direction that the trial court will proceed with the case against the applicant in accordance with law.